Our former health minister, Dr. Zweli Mkhize, has approached the High Court in Johannesburg, asking it to set aside the damning SIU report into the 155 million rand Digital Vibes contract. Now, in court papers seen by Newzroom Afrika, Mkhize, who resigned in August, wants the court to declare the SIU investigation unlawful and unconstitutional. He says the probe was procedurally flawed and that the SIU had withheld information from him with the intention to ambush him. Well, Mkhize says the SIU never shared the claims made against him by the department's former Director General, but it relied on these allegations to make adverse findings against him. He also alleges that the SIU disregarded his own version of events, which would have led to a different conclusion. Well, let's get legal analysis now, and we're joined by legal expert, that's Mpumelelo Zikalala, who joins us from eThekwini. Babu Zikalala, thank you very much for your time. Can I start with this question? The fact that the SIU has not referred the name of Zweli Mkhize to the NPA, does that mean that he has a fighting chance to review and set aside the findings of the SIU?
Good morning to you, Colin, and to your listeners. Not necessarily. Let's remember, the NPA is tasked with assessing whether if you take this matter to court, you'll be able to win. Not only to win in an ordinary manner, but to be able to prove beyond reasonable doubt that indeed the allegations that you come up with can be proved against the accused. Now, I think the SIU in this instance was playing it safe and saying, this is what we have. It's prima facie evidence at the moment. We have received all the statements that we have obtained, and we think there's something that can be pursued at a later stage. Now, you as the NPA, please go on and use the second step now and assess whether they can be able to make the charges stick in court and whether they need to be called to account within that particular judicial process.
The other key element here, Mr. Zikalala, is the wording of the SIU in its conclusions, and they say that, quote unquote, Mkhize may, that's the operative word, he may have acted in an improper and criminal manner by interfering in the administrative affairs of the department. Now, the SIU would obviously have to provide compelling evidence of this information, but this, though, would need to first go to the Hawks before, I assume, the matter is handed over to the NPA.
Definitely. The reason why they would say that, if you look at the modus operandi and to the allegations as to ended up benefiting within this whole process, does somehow link to the former minister. Now, in that instance, that is why they use the words may, because they are not saying, we don't want to shut the door so that at the end of the day we have absolutely exonerated the former minister, or we have painted him or tainted him as if he has done something wrong. We do acknowledge that from the face of it, it is something which must be accounted by him. However, we do not have the resources or nor the time, or we haven't traversed all the other avenues that are there. The structures that have the appropriate power in terms of doing the further investigations, the structures that have the appropriate power in terms of going to court, can then come in and do their work, and then only then you can then say is exonerated or not. Let's remember, there is Section 92 of the Constitution, which deals with the accountability and responsibilities of ministers. Now, it is very clear as to what a minister is supposed to do in terms of carrying their job, even though it was clearly defined within this particular section. But from the face of it, the inferences can be drawn that when it comes to legal compliance that falls within the minister in terms of saying, is this particular process in which my department is engaging in legally compliant, firstly. When it comes to strategy and governance, that's what it also comes up to. Now, linking back to the Digital Vibes investigations, you have the Mubane report that says, why are we taking all the decisions which have financial implications to the minister in terms of only limiting it to the DG? That is not a usual process that would be followed, even though it wouldn't be an anomaly. So those are the type of questions in which they could be better asked or answered within a court of law when those allegations have been made, especially because there is some type of direct or indirect benefit that has been obtained, which must be accounted for one way or another.
You referred to the DG, the former Director General, that the former minister is talking about in his legal papers. He says, let's try and tackle now what Mkhize is arguing. He says that the SIU withheld information from him with the intention to ambush him, and this has to do with that very information that they would have gleaned from the former Director General of the department. Does he have a case here that information at least should have been shared with him, so that I guess he tries to mount a cogent argument for why he may have acted in a particular fashion?
But just remember that the SIU is not the adjudicator in this case. They're investigating. So it's not up to them to assess whether someone is telling the truth or not, and who to believe and who not to believe. Their task is simple. Let's gather as much information as possible, and after we have gathered that particular information, we'll then be able to test and check, is this matter worth moving forward in terms of further investigations? Is this matter worth taking to court or not? So maybe procedurally he may have a leg to stand on in terms of saying, but you did not disclose the full information to me. The next question would be, how material is that information? So if you felt that it was important that this particular point should have been known, why didn't you say it in the first place? Why didn't you explain? Because once you've been asked by the SIU to come and give an account of what happened, you are not supposed to withhold information from them. You are the one who's supposed to say, this is my recollection of what happened in that particular instance, in this particular transaction. I believe that what I was doing was above the law, hence I'm here today disclosing all. So you can't then come at a later stage and say, but your withholding of information have limited my responses to you. The other question would be, what else are you limiting or withholding just because it wasn't asked within that particular interview?
Yeah. Let's look at the Mkhize family members. Let me put it that way. His son is alleged to have benefited as a result of the dealings with Digital Vibes. His wife, Dr. May Mkhize, also alleged to have benefited through these funds. Would the allegation that his family members also benefited here have a bearing on Mkhize's legal fight, or is that out of the question?
They would in this particular instance. Let's remember that when you go to court and you try to prove the element of corruption, for example, you then prove that there is some sort of gratification that has been received, maybe directly by the person involved or indirectly. However, without the influence of the person who was at court on that day, that would have not been obtained at all. So in this case, the case of the state would be, by you being the minister in this particular department, authorizing or having influence into this digital vibe contract, at the end of the day, there are members of your family that have benefited in a manner they wouldn't have benefited if you were not the minister.
Yeah.
Linked to this point, if at the end of the day this particular process does not go to court, then it means the minister will not get an opportunity to answer in terms of these allegations. When you look at them, they did occur. There's a financial footprint of the money going into one account, into another. Now, the question would be, did that particular relationship exist before he was minister, or did it only exist after this particular contract was concluded and all these transactions and the verifying or the notifying of the minister as per his allegations took place?
Yeah. Let's conclude our conversation, Mr. Zikalala, with this question. The expectation is that the SIU will oppose Mkhize's application in court, but there's a second respondent who is President Cyril Ramaphosa. Is there any obligation on his part to oppose Mkhize in court?
No, not necessarily. I don't think that he will oppose. He will simply say, I will abide whatever order that the court is going to give me. Let's remember, his let's say the innocent bystander who is simply saying, I've been put in charge as the president of the country to play an oversight role on all the ministers. After hearing these allegations, this is the investigation that I've ordered must be done. The report has come back to me, and I've tabled it to the relevant person, and they've resigned as a result of that. So I'm not going to get involved in this matter. What is of most important to me is the truth. If there's anyone that has transgressed in any law or any legislation, let them be brought to book and let them be made to be accountable.
Mpumelelo Zikalala, thank you very much for your legal analysis around the former Minister of Health going to court to try and set aside the SIU findings.